advocates that this is not the time to bring a suit in federal court because of the nomination of Republican appointed judges.
Let me answer that in part and let David finish. There are going to be many people in this country that think this is not the time to go to federal court, or you're not going to be successful in federal court. David and I have studied constitutional law. We both practice law longer than we'd rather admit. We think we know what we're doing. We think we've studied the Constitution. We've studied the United States Supreme Court. There are a number of very, very important decisions of the United States Supreme Court upon which this case is and will be predicated. One of the cases that David alluded to was Loving versus Virginia, when the United States Supreme Court held in that 1967 case that Virginia could not prohibit people of different races from being married. There are many important precedents, but we respect people that might have a different point of view with respect to the timing of a constitutional challenge. But when, as lawyers, individuals come to us and say, our constitutional rights are being denied to us, we have had this relationship with one another. We want to live in marriage like other people in California are entitled to do. We are not going to say to them, why don't you wait for another 10 years or 15 years? Why don't you just stay where you are and not have the same rights as the rest of Californians? We can't say that to them. We think they're right. We think their constitutional rights are being denied, and we're going to help them achieve that equality.
I think that reasonable minds can obviously differ as to when a constitutional challenge should be made and where and under what circumstances. But when you have people being denied constitutional rights today, I think it is impossible as a lawyer and as an American to say to them, no, you have to wait. Now is not the right time. I think that if we'd done that in prior civil rights battles, we wouldn't have achieved the victories that we have. I think that it is critical to understand that this is a present continuing violation. I also think that it's important to understand, and both Ted and I have said this is not a conservative liberal issue. Conservatives and liberals alike have a stake in the equal application of the laws. Conservatives and liberals alike have a stake in making sure that government does not intrude, does not limit the ability of people to exercise their fundamental rights, including the fundamental right to marry the person you love.
Do you think that when the state court yesterday created a separate class of people, it was 18,000 whatever it is, plus people who were same-sex marriages who are now legally sanctioned, did that inadvertently, do you think, help your case, and do you think that might have even been the intent of the justices? You're smiling.
Well, as Ted has said, I don't think any of us can tell you what the California Supreme Court intended, and I think you have to read the opinion for that. But I think it is clear that the decision does emphasize the lack of equal protection that currently exists in California.
Karen? When Mr. Olson, I represent the gay community. I represented it for 5 years in LA, and forgive me for this, but there's a tremendous suspicion in the LGBT community about your involvement in this, because we never thought you were pro-gay. So could you explain a little bit more and perhaps alleviate some of the suspicion? Because we see you with the Federalist Society, we see you aligned with groups who traditionally been opposed to LGBT rights. And that's for you and for Mr. Boies. The second question is, do you intend to address these issues, these very issues you just talked about, through President Obama, who seems to be delaying, movement on DOMA and on the military in particular? Do you think he'll be pushed to repeal DOMA?
Should David answer the easy question first? I don't think that I've ever been a part of any organization that was anti-gay or felt that gays are not entitled to equal rights. I have lived my life in a manner consistent with that. And the organization that you mentioned, the Federalist Society, believes strongly in limited government and individual rights. Each member of the Federalist Society has their own idea of what individual rights are, what limited government is, and what the free market is, and that sort of thing. The Federalist Society doesn't have any creed at all. It brings together people who want to debate important issues having to do with the law. I hope that people don't suspect my motives, but we've had lots of conversations about this. I feel very, very strongly that this is the right position, and this is the right position for America, and that I hope people will believe me. But all I can do is prove to people by what we do with this case and our actions that we really fundamentally believe what we're saying, and we're going to win this case.
Let me just add a point on that last question. I've known Ted well for over 10 years. We've been on the same side sometimes. We've been on different sides other times. I like it better when we're on the same side. He is a person that is committed in his heart and soul to equality. He is committed in his heart and soul to the Constitution. And that is why he is here, and that is why he asked me to participate in this litigation. With respect to the President, I would urge that the President move forward on initiatives that are important to establishing true equality for people of all sexual orientations. This is an issue whose time has not only come, but long passed, and we must move forward. I think it is important to move forward on every front. It's important to move forward on the fronts that the executive branch can control. I think it's important to move forward on the fronts that the legislative branch can control. And I think it is critical to move forward on the equal rights articulations that are the province of the courts. Thank you.
Can we hear from some last question? Can we hear from the plaintiffs just briefly about the importance to them of this particular?
We're supplying materials with respect to declarations that are being filed in a preliminary injunction. We've talked it over with them. We promised that this press conference will be about the filing of the litigation and to explain its parameters and how it came about. And there will be opportunities in the future for them. Believe me, they will have many opportunities to express themselves, but today is not the day. Thank you.
If you were to fail this case, it would establish essentially a right to marriage by same-sex couples in every state, right?
Pardon me?
If you were to prevail in the case in America, that would establish a nationwide right to marriage by same-sex couples in every state.
Yes. Well, the principle, and I think we're done at this point, the principle that we're expecting to establish in this case, that the United States, the Constitution of the United States, just as the Supreme Court held in Loving versus Virginia, that the Constitution prohibited states from restricting marriage to people of different races, that the Constitution of the United States protects the right of individuals, same-sex individuals, to receive the opportunities and blessings of matrimony just like the rest of us. Thank you very much for being here.
Thank you.